We begin this morning with Amendment 4. On Thursday, the Florida Supreme Court delivered its long-awaited answer to the question Governor Ron DeSantis asked it last year. Does the phrase "all terms of sentence" in Amendment 4 include fines, fees, and restitution? The court's ruling was clear. Yes, it does. And its reasoning relied primarily on the fact that the sponsors of Amendment 4 specifically said it did multiple times. When sponsors wrote their brief to the state Supreme Court trying to get Amendment 4 on the ballot, they said people with felony convictions other than murderers or sex offenders, quote, will automatically regain their right to vote upon fulfillment of all obligations imposed under their criminal sentence. When they argued in front of the court, Justice Polston asked whether all terms included full payment of any fines. They said yes, all terms means all terms within the four corners of the sentencing document. The ACLU said on its website and in its voter guide in 2018 that Amendment 4, quote, included any probation, parole, fines, or restitution. The ACU and other sponsors said the same thing in a letter to the state about how to implement Amendment 4 in mid-December of 2018, a full month after it was approved by voters. That letter said, quote, the phrase completion of all terms of sentence includes any period of incarceration, probation, parole, and financial obligations, which may include restitution and fines imposed as part of a sentence or a condition of probation. The ACLU and those groups are now part of a federal lawsuit challenging the law that was enacted by the legislature to administer Amendment 4. They argue the new law violates the U.S. Constitution, effectively creating a poll tax. U.S. District Court Judge Robert Hinkle ruled in October that people who can't pay those costs can't be restricted from voting. We spoke to Tampa State Representative Jamie Grant, who chairs the legislature's Criminal Justice Subcommittee. He was happy about the state Supreme Court's ruling this week, but Hinkle's ruling, he says, is wrong.
What he has created is a system that says you only have to pay restitution if you can afford. And I just don't think a two-tier system of justice is the way that things should work. We created the waiver process on purpose, which would allow the payee to come in and say that they are going to waive payment, and that would serve as a pathway for people who may not be able to afford. We created the community service pathway for people who wanted to earn that may not be able to pay, that want to earn credit for those dollars by doing community service. We created a lot of different pathways for people, but at the end of the day, you have some people who want to treat victims like criminals and criminals like victims. And that's not going to be the posture of the Florida House or certainly our Criminal Justice Subcommittee. But our subcommittee will continue doing what we've always done to try and provide greater access to justice and a more equitable criminal justice system.
And Judge Hinkle has said that, you know, if you don't fix it, it's a possibility he could throw the amendment out as unconstitutional as a poll tax. Mm-hmm. Cynics would say there's no incentive for the legislators who don't like Amendment 4 to do anything, because then the judge would get rid of it.
Yeah, I think there's two things. I have not had a single person tell me they don't like Amendment 4. I've had conversations with colleagues of mine who say that we would have done it differently. I'm one. I would have created greater restoration for a smaller pathway of people. When I say a smaller pathway of people, one of the things that is a misnomer that people don't realize with Amendment 4 is that the message was this is a nonviolent population. That's just fundamentally false. Attempted murderers, violent habitual felony offenders are covered by Amendment 4. It's not easy to become designated as a violent habitual felony offender. These are people that are real dangers to the public. And so that limited our ability to provide full restoration last year. We've been spending the offseason working on that. But I don't know anybody that doesn't like or has a problem with Amendment 4, number one. But I think Judge Hinkle's bigger problem is created by the ACLU's patent lies and disingenuous litigation, right? The ACLU obviously part of a letter back to then Governor Scott, very clearly acknowledging what terms of a sentence included. They've now done a 180, and they've brought out the dog whistles and the demagoguery to suggest that this is, you know, some sort of Jim Crow era policy. Here's their problem. Probation is a financial obligation. So the very plain text of Amendment 4, before you even get to the very sensible and logical approach by our Supreme Court this week, before you even get to the interpretation of what all terms of a sentence means, the word probation is in Amendment 4, and that's a financial obligation. And so the ACLU, trying to raise money in memberships, has gone out there and beat the drum that the Florida legislature, led by GOP people, wants to suppress the vote of certain people, and in doing so, they have threatened the very existence of Amendment 4, because if, in fact, any financial obligation prior to the ability to vote for a felon is a violation of the 24th Amendment, then Amendment 4 on its face is a poll tax. So by their definition, they campaigned for, they raised money for, and they asked people to vote for a poll tax. It makes it quite evident that they're not actually in the business of trying to restore or re-engage citizens in democracy. It makes it quite clear that the only thing they're interested in is their own pocketbooks, their membership, and their own relevance.